If the deed to your property is missing pertinent information, it could be rendered invalid. Sometimes the error is considered minor and can either be disregarded as not affecting title to the property or can be fixed by the signing of an affidavit or corrective deed. And some errors are more severe and require a court action to truly protect your interest. Today you'll learn what is required for a deed to be valid in Florida, and if you listen to the very end, you'll get the inside scoop on an often misunderstood requirement that is left off of many DIY deeds that are not prepared by attorneys. I encourage you to pull out your deed from closing to see if you can spot any issues. In previous videos, I discussed things like the top 3 ways that a quitclaim deed can burn you, which included everyone's favorite consequence, an increase in your property tax bill. I've also gone over the differences in the warranties available to a new owner under a general warranty deed versus a special warranty deed, as well as the fact that a quitclaim deed comes with no warranties at all. But the formalities discussed today apply to all forms of deeds. In order for a deed to be effective in Florida, it must be in writing, identify the parties by name, have a post office address for the new owner, which is where the property tax bill will be mailed, must describe the property, not just by a street address, but by the more detailed legal description, have operative words of conveyance, the most common on a warranty deed being grant, bargain, and sell, be signed by the owner who is transferring title, be signed before 2 witnesses who also must sign the deed, and a relatively new requirement that went into effect this year is that the witnesses' post office addresses must also appear below their names, and the deed must be notarized. There should also be a statement at the top left corner of the deed with the name and address of the person who prepared it, regardless of whether that was one of the parties themselves or an attorney. If any of these requirements have not been met, the clerk will not accept the deed for recording in the public records. In addition to the minimum requirements for the deed to be valid, the county where the property is located may have additional requirements. One of the newest requirements, so far only in Lee County, Florida, is for a photocopy of a government-issued photo ID for each grantor, who's the person transferring the property, and for each grantee, the person becoming the new owner of the property, to be presented along with the deed. Besides what the deed must have printed on the face of the document itself, the parties must have legal capacity, meaning they are of legal age and have the mental capacity to understand the terms and conditions of the transaction, be signing off on it voluntarily, and must actually deliver the signed deed to the grantee. And lastly, the often misunderstood requirement relates to the grantor's marital status. Because the transfer of homestead property by a married person requires both spouses to sign the deed, even if one of them is not an owner, the deed has to express the marital status of the grantor or a statement that warrants that the property is not the grantor's homestead within the meaning of the Florida Constitution, and then indicate the address of their homestead property. If you'd like me to review your deed before you get ready to sell, send a text to 561-225-2676 to set up a time to speak with me.